Our next speaker is Linda Woolf. Linda is the managing partner at Goodell DeVries Leech Dann in Baltimore. She defends class action and multi-district litigation, complex commercial, insurance coverage, construction, and other complex cases. Since 2009, Linda has been listed in Best Lawyers in America for Bethel Company litigation. Today, Linda will talk about the fuzzy lines that appear at the confluence of large losses, high self-insured retentions, and insurers at different levels, which present the possibility of an out-of-control situation for in-house counsel. Please welcome Linda Woolf.
Good morning. I will bet you that any number of people in this room have lived these situations and in all sorts of different permutations. But what I'm here to address today is the various tensions, the competing rights and interests, and what happens to a defendant company and its insurers when a catastrophic loss occurs. Any catastrophic loss can present unique and very complicated questions of coverage for the company that's involved, its primary insurers, its excess insurers. We may be involved in these cases as in-house counsel representing the insured company, the defendant in the case, as in-house counsel representing its primary or excess insurers, defense counsel who might be retained by the company, defense counsel who might be retained by the insurers, or coverage counsel for the company or for its insurers. There's a lot of roles to be played, and as you know, at any given mediation in one of these cases, there may be lots of people in the room with competing interests. What kind of cases lead to this? Well, examples can include catastrophes such as airline or rail disasters, building collapses, and situations that in very complicated scenarios cause multiple deaths, personal injuries, catastrophic property damage. Later today, I think Forrest Wynn is going to talk about a catastrophic case in which he had very up-close and personal experience, but I'm going to speak a little more generically, although from recent experience. These cases inevitably generate massive litigation with tremendous exposure for the companies and their insurers, both from litigation expense and from liability payments. And because they almost always arise from really complicated situations, they lead to very complicated coverage questions, just when a company most needs insurance protection. So, what are the kinds of scenarios that lead to this? Well, I'm going to give you some hypothetical examples. Let's say there is a technology company that was hired to design and install software for a public transportation agency and to train its personnel. The company develops and sells to the company, to the rail agency, a proprietary information management system to manage the traffic on the rail system. A few years later, an accident occurs. And it causes multiple deaths, dozens of personal injury, property damage, and it's alleged to have been caused or contributed to by the company's software. Another way such a case can arise is a construction company is designed or is retained to design and build a walkway. In a large building, the walkway collapses, there are multiple deaths, personal injury, and property damage. An environmental company designs and installs a toxic waste system which fails. Massive property damage, perhaps personal injury. So what happens? These sort of catastrophic losses implicate multiple insurance policies on both primary and excess layers, and they may be different types of policies. They might, a company of the types we've been talking about will have commercial general liability coverage. It'll have errors and omissions coverage typically. They'll have excess policies sitting on top of both primary policies, and they may have umbrella coverage. Large companies have multi-tiered insurance programs, and they are typically some combination of self-insurance or primary insurance, excess insurance, which might be in successive layers, some of which might be shared, and umbrella insurance, perhaps. Now, the types of coverage questions that might arise in a catastrophic loss case are complicated when a company has two towers of insurance with different lines, each of which is multi-tiered, each of which might be implicated by a catastrophic loss. They're subject to different terms and exclusions, and this typically will arise where a company provides both professional services and sells what can be characterized as a product, or performs non-professional services as well. Let's go back to our example of the technology company that sold a software system to a rail agency. Here, the company has in place, hypothetically speaking, none of these are real companies, but has in place both commercial general liability coverage, or CGL coverage, which is written on an occurrence basis. It has a minimal deductible. Defense expense is outside the liability limits of the policies, and it's a large tower of coverage, $35–40 million of coverage. That coverage will provide for product liability coverage. That CGL coverage, or CGL policies, will provide coverage for product liability claims. The company also has errors and omissions, or E&O coverage, which provides coverage for professional services. But this line of coverage, as you can see, is subject to a large self-insured retention, and it's a much lower tower of insurance. In our hypothetical example, did the company's exposure arise from a product liability coverage, which would come within the CGL policy line of coverage, or did it arise from professional services, the design of the software system? Well, we'll come back to that question. And first, we're going to talk about the components of both lines of multi-tiered coverage. Primary insurance, as you know, will provide usually first dollar coverage, and it attaches immediately upon the happening of an occurrence. The primary carrier's obligation is to both defend and indemnify the insured. Some businesses, for various reasons, elect to self-insure at the primary level up to a certain limit. Self-insurance entails the same obligations as commercial primary insurance. In other words, under the self-insurance, or within the self-insurance layer, there's an obligation to both defend and indemnify from the first dollar. Self-insurance can be achieved through an SIR, a large SIR, self-insured retention, which attaches at the first dollar, and it must be paid out before any obligation for an insurance company that sits above the SIR has to respond. SIRs can be significant, sometimes millions of dollars. Companies typically will put in place a large SIR to both defray expense of commercial insurance, but also because a company with a large SIR has a lot more control for a routine claim. They are usually allowed to select defense counsel, make settlement decisions for claims that come within the SIR. When representing a company with a large SIR, it's important as defense counsel or as in-house counsel to recognize the notice requirements and the communication obligations that you still have with the insurer that sits above the SIR. You need to communicate early and often with that carrier whenever you are dealing with a loss that might exceed the SIR. It's also important to know whether the SIR is written on a per claim or per occurrence basis, or whether it's an annual aggregate. Does the company need to satisfy the SIR for each claim, or once satisfied within a policy year, is the commercial insurance going to respond? Some companies self-insure through captives. A captive insurance company is generally based offshore. It's owned by those it insures, and these are actual insurance companies. They're not regulated by any state insurance commission so long as they conduct all of their business offshore. They write very tailored coverages for their insureds, and the policies that they issue look pretty much like commercial insurance policies, except that they're usually written on a reimbursement basis. Companies that have captive insurers generally have excess insurance as well and reinsurance through commercial carriers. But regardless of whether a company self-insures through an SIR, has a captive insurer, or has commercial primary insurance, they also, if they're of any size, will have excess insurance, which doesn't need to respond until the underlying limits of coverage or an SIR is satisfied. Most excess insurance policies have no duty to defend, so they're not required to defend the insured until those underlying limits are exhausted. But it's important to know that excess policies typically give to the excess insurer a right to participate in the defense. That's why it's important that the excess insurers be aware of everything that's happening in the underlying case, where it's likely that the excess insurance will be implicated. Umbrella insurance is a little different. It's not the same thing. It will sometimes drop down and act as a gap filler where there's a gap in coverage, and it may provide broader coverage than an excess policy. So, in a catastrophic loss scenario, like we were talking about, where a company has separate lines of insurance that cover different risks, you may have a situation where the primary insurers are each saying, this is not my baby. This is a product claim, this is an E&O claim, and there may be some, there's likely to be some tension between the two insurers as to who's got to step in and cover. Likewise, an insured who has first dollar coverage on one side and perhaps a large SIR on the other side is going to want to characterize loss in a way that gets it first dollar coverage. In our rail company or rail disaster case, we have a situation where the technology company has first dollar coverage for products claims, a large SIR for E&O claims, not that much coverage on the E&O side, lots of coverage on the CGL side, and defense expense, which is eroded on the E&O side, and outside limits on the CGL side. Which do you think the company wants to implicate, or is it both? And if it is both, how do the policies relate? Well, in a situation where there are allegations that really could be both professional services and arise from product claim, let's say the CGL carrier and the E&O carrier both accept that the allegations implicate at least a defense obligation on both of their parts. But there's a big SIR on one side, no SIR on the other side. And the CGL carrier, who has no SIR, and just a minimal deductible, steps in and defends from the first dollar. And because defense expense is outside that carrier's limits, it incurs defense expense that far exceeds the limits, far exceed the SIR on the other side, before its limits are paid out in liability payments. When it's exhausted, does the E&O carrier need to immediately step in and start defending, or does the insured then need to satisfy the SIR on that the E&O coverage is subject to? Well, there's authority going both ways. There is authority that stands for the proposition that unless the E&O policy is written to state that the SIR must be satisfied by the insured's own assets, it can be satisfied by other payments. In other words, the CGL carrier just paid close to $4 million in defense expense, $1 million in limits to settle a few of the cases that arose. Does the insured then need to pay $1 million of its own money before the errors and omissions carrier is implicated? There's authority that says yes, there's authority that says no, and it's important to know what controls in the jurisdiction that your company may be in. Now, in a catastrophic loss scenario where you've got coverage where defense expense is outside the limits, typically primary insurers are called upon to spend many times their limits, or they may be, in defense costs. These insurers know at the outset that their limits are up and they're going to be paid. But they also know that they have an obligation to defend until their limits are paid out in either settlements or judgments. That's the way most primary policies are written. There may be policies that state that the limits are eroded by defense costs, but typically commercial general liability coverage is not. Claims may, or E&O coverage may be, is more likely to be. But if the policy limits are not eroded by defense costs, primary insurers who know that their limits are gone and know that they're paying many times their limits in defense costs may, just imagine, they may be interested in paying settlements as quickly as they can and getting off the risk. But they cannot enter into unreasonable settlements that for the sole purpose of paying out their limits and walking away. The interests of the insured are paramount, and as defense counsel, we are called upon to give the insurance company solid, good advice on the reasonableness of settlements, as well as the defendant company, the insured. You need to evaluate settlements carefully and bring them to the table. They should be settled if they're reasonable. If they're not reasonable, the primary carrier continues to defend, continues to pay out lots of money. Typically, it's not all that happy about that situation, but that's what primary insurance is for. Primary insurers, the other thing they can't do is just put their pay their limits into court or turn their limits over to the insured and say, here you go, we're done. The excess carrier needs to respond again now. Now, what happens after the CGL policy is exhausted, triggering an obligation on the excess for the CGL excess to respond, but the E&O primary policy is not yet exhausted. What is a company and its counsel to do? Make sure the lines of communication are open. Do these companies share? Does the E&O policy have to exhaust before the excess policy has to respond on the CGL side? You need to look very carefully at policy terms and controlling law in the jurisdiction. The primary point I can tell you is that it's very important as defense counsel to communicate. There's a duty to notify the excess insurers, and if you are going to be settling cases that within the primary limit that will then trigger the excess carrier, it's important that the excess carriers be kept up to date on the status of the litigation, all of the settlements. You need to tell them what the settlements are, what they're for, why they're reasonable. That way, you will not run into a situation where the excess carrier is saying, I don't have an obligation to respond because your settlements weren't reasonable. This is not a fair exhaustion of the policy. They need to know about every settlement you're considering and why it's reasonable. But there's another tension that can arise. If the excess carrier has issued a reservation of rights, your interest, the company's interest, and the carrier's are not aligned entirely. In that case, you need to be careful of privilege issues and communicate the information that the excess carrier needs to know, with the knowledge that a third party may challenge that and say that this is not a privileged communication. That has happened. Typically, typically companies and their carriers have been able to protect the information, but it's worth knowing that you need to get the excess carrier on board and have them agree that the communication that you're having with it at the time is subject to the attorney-client privilege, notwithstanding the fact that there's a coverage question and a reservation of rights, or even a declination of coverage, in which case you probably aren't communicating. The bottom line is, following a catastrophic loss, the insured and all of its insurers have a common interest in limiting the insured's exposure. But their interests may diverge when the insurers are called upon to fund defense, fund settlements, and there are coverage questions. Then outside counsel and in-house counsel representing an insured in these large exposure cases must understand all the divergent interests that are implicated and keep the lines of communication open. there are fine lines that must be navigated, but at the end of the day, what you want to happen is your client to come up to you and say, we are very impressed with the way you handled this case. The insurance companies to say, we are very satisfied with the way you handled this case, and the insured's exposure has been minimized to the extent you can, and the insurance companies have paid out only reasonable amounts. Thank you.